I am here with Mandy Nease for a live Q&A, behind the scenes, insights from a former USCIS adjudicator. So for everybody who is on this session right now, you can please start asking questions and we're going to add them live. We also have a few questions that that were pending from our last webinar, and that's why the webinar was so successful that we said, hey, Mandy, why don't we do this again, volume 2, right? Hi, Mandy.
Hi, Marianella. How are you?
Good, good. It's nice to have you here closer in Miami Beach. Welcome.
Thank you. Thank you. Good to be
Great,
here. Thanks for
Mandy.
having me back.
Yes, of course. I mean, and not only me, everybody wanted you back. So it's great
Oh,
news that you could make it. We really appreciate it.
thanks, everyone. It's really sweet.
Wonderful. So, Mandy, before we get started with the questions, tell us a little bit about your experience at USCIS. Where was it? When did that happen? How was that experience? Tell us a little bit about that.
Okay. I started USCIS in late 2008 at the Nebraska Service Center, which is in Lincoln, Nebraska. And I started there as an adjudicator as a result of the 2007 visa blizzard. I don't know if any of you remember that, but USCIS had opened up and made every category of visa available for a brief amount of time. And, as a result, they were just really flooded with applications and they had to hire up. And so I was part of that hiring wave. And I was there from 2008 until 2021.
Amazing. And how does it feel now, Mandy, to be on the other side of the playing ground?
It's good. I mean, it's really good.
You rather be here or there?
It's good to be here. I prefer this. I've just been really lucky at my firm because I get to do a lot of different things, including stuff like this. And it's really been healthy for me because adjudications is such a grind. It's so repetitive. And even though, I really work to get other things going. I was a union rep and an EEOC rep, and I had a national council position, and I was involved in the local union and things like that, and the employee association. But the job is still the job, right? You're still adjudicating, 6 or 7 hours a day. And so it's been really, really healthy for me to be on the other side, to be helping a firm that represents a diverse client base where you have like a lot of creativity. The petitions aren't all the same. And then also to be empowered to do professional development at my firm and to do some things like this. So for me, it's been really, really good. There's times when I kind of miss the inside scoop, and there's definitely times when I wish I could call someone that I actually know and and ask them what the hell's going on. But mostly good. And certainly with the political situation, I do not miss being a federal employee even a little. Yes. And so that part, it's all been really, really good, honestly, because the firm, they've just been really supportive of everything that I've wanted to do. So
amazing. That's great, Mandy. And I remember in our last webinar, you were saying that sometimes when you read RFEs, you think who wrote them.
Yeah.
And I think that's amazing. I mean, that's getting like information from the inside and knowing a lot.
Yeah, when it is nice, but then it also, I get very offended personally.
You're not the only one, I can assure you.
I'm sure
there are 1,000 immigration lawyers watching.
Yes, it's very tough not to take it personally when like you know who the person is, and it's very hard to take it personally anyway, because that is your work and it's your client and you're pulling for them and you believe in the case. So yeah, I mean, it's really hard not to personalize it, but then to even have that background, and to not just want to, you know, do get in someone's face.
Yeah,
You know?
add the emotion to the RFE
Yeah,
response, right?
I know where they hang out. You know, like
Please don't say it out loud. Mandy, and just for the audience to know, what types of visas were you in charge of adjudicating when you worked at USCIS?
so I started doing 485s, right? Because it was the visa blizzard, and that was the work that had to be done.
Do you know if USCIS has been using AI on their adjudications? And if so, what is the impact of it from your point of view?
So, to my knowledge, they have not been using AI in the adjudications. Okay. There is a plan to have some AI document review, but there are no plans to have AI in the adjudications process at this point.
Okay. And I think it's a good opportunity to talk about the CRM that you say they use for RFEs. Can you tell us a little bit about that, Mandy?
That's yeah, it's a drafting software, and the way the software works is it's queued to those receipt numbers. And so the receipt numbers are entered, and then that pulls up the type of petition that it is, or the type of application, and it gives you the language that's available for that petition. Right? So for I-140s and NIWs, there are different language snippets, as they're called, that are available, versus if you were doing like an I-90 renewal or replacement or something like that. So
okay,
they only apply to that petition type. That's all you have access to. I do think that I-140 officers tend to keep their own snippet bank or their own pre-canned language bank. If they find language that they like that addresses concerns that they see over and over again, then they will kind of keep their own bank as well.
Okay. No, and that makes sense, right? Because a lot of immigration lawyers say, okay, this seems like a templated RFE, or in other instances, maybe the file was supposed to be for a pharmacist, and then they said, yes, they're great at soccer, and then yes, and then that tends to happen. But what you're saying,
Yeah.
I mean, explains a lot of how and why that would happen.
Ideally,
Okay.
those get edited, and ideally, we don't have a lot of true cut and paste, right? Because the software is keyed to that particular case particulars, right? So it's going to pull in the name of the beneficiary and the name of the petitioner and the classification and things like that. So to me, when I see that, I know that they're cutting and pasting from their own bank.
From their own. Okay.
Yeah, that's what I think anyway. I mean, I could be off, but that's my opinion.
So it's the individual, not the institution.
And it's not that software. I mean, no one's going to write a document drafting software that includes that level of specificity for the facts, right? I mean,
exactly.
You have to queue yourself, like even in the templates that we use, you have to queue yourself that certain sections need to be changed and customized to that particular case.
Exactly, to avoid that to happen, because from what we hear from immigration lawyers, it seems to be very, very frequent, right?
Yeah.
So hopefully technology also has some progress and that could be improved. Let's see. Okay, we have another question from Maria Clara. Can you give some insights on the do's and don'ts of petition presentation? Anything we can do to make the officers' work easier and more enjoyable? Example, index, labels, color codes, bold, most relevant context, etc. Do they help or are they irrelevant?
They're relevant.
Okay.
Be concise. Be concise. With your dividers, exhibit dividers, I like to have like an exhibit number and then the type of evidence that we're talking about, right? So the page could have an exhibit number and then whether it pertains to prong 1, 2, or 3 or preference classification, something like that. You could get into the weeds a little bit more and do, like well positioned, commitment, well positioned, record of success, well positioned, interest from U.S. customers or clients. You could do that if you wanted to. The other thing that I talk a lot about at my firm is the brevity of the cover letter. I'm not one to promote long, lengthy support letters, although I understand why law firms do it, right? It's part of our service to our clients. And we all know that sometimes the files don't get the time that they deserve. And so structuring the information and kind of explaining the information and the argument has a purpose. I don't want to imply that it does not have a purpose, but I'm just in favor of being concise in those statements and, just really getting to the point and helping the officer understand the structure of the information and then letting them, make their own conclusions, which they will do anyway.
Exactly. And I remember you mentioning about the length of the cover letter as well. And then you mentioned also the table of content and the fact that all items have like a brief explanation so that it's pretty straightforward why the purpose of why it's there, right?
Well, that's my dream support letter. My dream support letter is like an annotated table of contents. No one will let me do it. Maybe someone brave in the audience wants to pilot that. But yeah, I mean, I don't think a brief annotation of the table of contents can hurt either. Again, structuring the information, right? Like what purpose does this piece of evidence serve in my presentation of the case?
Okay. So then color codes is a no, bold is a no. Okay.
Save your ink. Save your support staff. Save
okay.
your
Less is more.
Sanity. Yeah.
Okay. 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 And I have another question, but it was pointing to the same thing. Considering the time constraints, is there an ideal size? Okay. Ideal size. Let's talk about length. Do you have a range of what you preferred when you were reading them?
No. And I never really knew, right? I mean, I think it's probably easier to tell now, like the total page length because they're electronically adjudicated. But when you're doing a paper adjudication, all you know is whether it's like looks about right in terms of the size or whether it looks on one end of the spectrum or the other to be, overly thick
no, but I mean the letter only, the petition letter only.
Oh, the petition letter. Oh, I'm like a 10 pager. Like, I think you could get it done in 10 pages, but I'm also not a page counter. Like, to me, think about what you're saying. I don't like repetition. I don't like overly verbose writing styles. That's not my style. Get to the point and think about it like this for the attorneys in the audience who have done high volume appearance work, right? If you've ever practiced in front of a high volume court, you think of your adjudicators as in a similar way, and just get to the point. You don't have to not do your job, right? Explaining the information, but you also don't have to drone on in front of a person who has a large docket. So exactly. Finding that balance, I think 10 pages can get it done most of the time, but I wouldn't be, just don't be overly rigid about that either.
Okay. So aim to 10, but then if you add a little bit more, that's okay.
Right.
As long as everything is there. And Mandy, well, I think this answer is what surprises the audience the most, because we had it last time. How long do adjudicators have for, let's say, EB-2 NIWs to review them in average, ballpark?
So I think the production expectation is that you do 1.5, I think, ish an hour. So you have about 30 minutes tops to do everything you need to do for that petition, right? So you're going to be running security checks and running financial checks, not on NIWs, but for like the average labor cert case, you'll be running security checks on the beneficiary and financial checks on the petitioner. Wow. And with NIWs, it's a volume issue, right? I mean, you have a lot of pages to look at in that 20 to 30 minutes. And then you also have to make your updates and enter your decision and make it all official. So, and some of them take more and some of them take less, right?
Exactly. But we can talk about an average of 30 minutes. Yeah. Immigration lawyers, please don't get scared. I mean, we know it's a lot of time that you take to prepare it, but yes, the average is around 30 minutes for them to review it. But then that goes back to what you were saying before, Mandy, about the length of the cover letter and the fact that things are organized but not repetitive or overly lengthy, right? We have another question from Helen. What kind of training does an officer get?
Oh, that's a good one. You get a lot of training, and I actually am a big fan of the government's training, and I have brought a lot of that structure to the training that I do at our firm because it's so effective. So the first thing that officers have to do is they have to go to basic officer training, and that's like 6 weeks. Used to be off-site, but I think it depends on the office now, whether that's done at your home office or whether you travel. And then you have some systems training that occurs at your office. So you know how to operate, the 37 computer applications that officers need to use. And then there's general training too that are just pertain to issues around USCIS and the federal government. You'll have internet security training, you'll have human trafficking training, active shooter training, things like that. And then you'll have your forms training. And the forms training, which I think is what everybody's curious about, like how do you learn to adjudicate? That's about a week of classroom training. And then you have practice files that you're given and you're assigned a mentor. And the mentor works the first 5 files with you completely. Side by side, they're considered co-adjudicated. That's how they refer to that. And that's to make sure that you know all of those things, right? That you know how to apply the law and you know how to operate the computer appropriately so you're not making errors and things like that. And after the first 5, then you kind of get authorized to do additional training cases asymmetrically. So the student takes, 10 or 15 files. They have a checklist, which is another common question, a checklist, and they will make notes about the decision that they think they will make. And then they turn those files over to the mentor when they're ready, and then the mentor takes a look at the checklist, they take a look at the file, they take a look at the notes, and if they concur, they will write you a note back that says, I concur with this decision, proceed, whatever. If in the case of an RFE, they will have you draft the RFE and they will review the contents of that. So that goes on. There's a set amount that's like initial, and then you get a few more. Okay. And then when you've done, I can't remember if it's 20, 15 or 20 with the mentor, if the mentor feels like it's going well, right? Like you're picking it up, you feel good about it, you're not struggling, then they will sign you off and you submit. You do that again with your supervisor.
Okay.
And the supervisor does that same thing. They observe your work. They see if they're going to concur with your decisions. They review any RFEs that you think should be issued. And then if you pass that section of the training, then you're signed off. And then, for most people, they continue that mentoring relationship and they continue a close relationship with the supervisor to make sure, that those the first month or so of adjudicating on your own, that you still have a lot of support, because there's so many different kinds of cases. It can be really tricky to really feel like you know the product well enough to really be on your own.
Exactly.
And so for I-140 officers, that happens with labor certs, and then they will have their specialty form type training, right? So I-140 labor certs are the core product. And then you'll also be trained on a specialty, which would be one of the EB-1 subtypes, national interest waivers, or Schedule A's. They try not to assign too many subtypes. I had national interest waivers and Schedule A's in addition to labor certs. But if you do one of the EB-1 subtypes, that's typically all you get, because those are considered to be, that enough on their own, I guess.
And I remember you mentioning that sometimes it may happen that some officers might mix up a visa. Maybe they're checking an NIW and they think they're reviewing a perm or something like that.
Yeah, it can be easy to, pull other information in. And I think we can all do this, right? So we started seeing national interest waiver petitions have language about being a public charge. Because we, for many NIWs, we weren't, including financial information. And they were asking about financial information, which isn't really in DANISAR. It's kind of extra to DANISAR. And so my reaction to that was, I think there are 485 officers who have been reassigned to I-140s because a public charge question is a 485 question.
Exactly.
Just like with the EB-1s, if you've been working E-1-1s, as they're referred to by officers, which is the extraordinary ability, EB-1A, as we call them in private practice, you might see those EB-1 criteria, the extraordinary ability criteria, start coming in. You might also start to see what you think is like a higher bar, right? Exactly. Like a different standard of review. And so I think all of those things can reflect an officer's history and how recently it's been since they have been trained on that new product.
Exactly. Thank you for that, Mandy.
Hangover.
The hangover.
Right.
Are you still filing cases related to environmental issues and sustainability, especially in light of the priorities set by the new administration? Question by Estrella.
100% I am. And I'm bearish on climate change, and I'm bearish on social issues. I'm bearish on all those things because I don't know that the average adjudication officer is all that in tune with the president's agenda, and none of the guidance has changed, right? So, for example, if you have a lot of climate change petitions are going to have some kind of advanced technology in them. Your STEM adjudication guidelines are still in place. All of those things. And the officers still know. We still have climate change goals. Exactly. We still have a lot of things. He hasn't really cleaned up enough government policy to have climate change not still be a goal. He's done a lot. I'm not going to sugarcoat it, but he hasn't really erased that in the way that I think.
Ooh. Mandy got off again.
Oh my
Oh,
God.
Mandy, are you there?
Yeah, I'm here. Sorry.
You got too excited on the topic. Okay, so then yes, you consider that. I mean, you're still filing those. You were
Yeah,
saying.
100%. 100%.
Okay.
And social issues, I'm still filing those too. We'll see. I mean,
Hmm.
but yeah, I still do
Exactly.
them. 100%.
Okay. Another question from Sina. People say if someone reaches out to the USCIS through Emma or phone call, it will jeopardize their case. Is that true?
I don't think so. You
Okay.
mean like this is something I hear in my office a lot too. If I complain or if I peep, am I going to be punished?
Uh-huh.
I never punished anyone for making a customer service request. I mean, is that beyond the realm of possibility? I probably not, but I never punished anyone for asking. And usually you could tell, right? You would get, so a lot of times those older cases that have been sitting there for a long, long time, they used to come up, in the physical land, they would come up to your desk with a service request form on it. And the supervisors at Nebraska, they would conduct computer sweeps to try to go out and find old cases that needed to be worked, that maybe had somehow gotten off track, right? So your supervisor would assign them to you and be like, these all need to be worked. They're old. Can you work them? And you would just, sometimes the supervisors would have a pile in their office and they would just leave everyone on the team a note and say, please come by my office when you're in and pick up 2 to 3 or pick up as many as you can, whatever the instructions are. And then you go work them just like any other case. A lot of times it was officer reassignment and something like an RFE or something like that had been issued. And then when it came back, that officer wasn't there.
Hmm.
I don't know exactly how it works in the electronic system, but I think it probably works the same way. It should not be happening, and most officers will know if something's been sitting there for 15, 16 months, they're going to understand that, right? Like,
Hmm.
yes, I would want my decision too.
Exactly.
They're not, I mean, are there officers out there who will get spicy? Sure. And I think that there's a little spiciness right now because of the bubble in filing around the US election. There were a lot of cases that were filed and a lot of cases that were filed premium. All the officers that are working right now are premium cases. And we all know they're doing refunds. They're blowing their
Yes.
premium deadlines. There's just so much work. They're stressed out and spicy.
Yeah.
I mean, I'm sure no one here ever has that.
Exactly. Everybody's extremely mindful. Everybody's patient.
Right.
Nobody has a bad day. Exactly.
Right, right. No one ever snaps at
At
anyone.
anyone. No. No, and I,
This
yeah,
this profession in particular, I mean, we're just known.
exactly. No, and I like that approach, Mandy, because just talking to you, it feels like we can humanize a little bit of USCIS, although there's like all these assumption and stereotypes about how the officers are or aren't. And it's really nice to talk to you because we get a more humanized approach to who's working right behind the scenes. So that's important as well. Another question from Yun Huan. If an RFE is not responded and the case is withdrawn, will it have any effect on change of status filed later?
So this is an I-140 that's withdrawn. It gets administratively closed, and then you file something else, and they change status on a non-immigrant status. Am I understanding that? So I would say no. All of those cases are done without prejudice. They're
Okay.
not the denials for an I-140 or for a permanent petition type should not have any bearing on a non-immigrant visa petition type. And in many instances, the officer will have no awareness of that other filing unless they go looking. Everything's going to come in a discrete file for that officer. That officer is not necessarily going to have authorization to go look at other types of filings.
Of course.
Okay, so your access is based on your need to know. Now, could they see that an I-140 was filed and could they see that it was denied? Yes, but they're not going to really see anything else. So they're not going to be able to dig in and be like, well, they withdrew this I-140 and that was some immigrant intent. And so I'm going to now deny this H-1B. They're not going to do that.
Okay.
No one has time.
30 minutes average. Now you know.
Right.
If it is a refile of a denied case, will it help or hurt if we mention it is a refile? Will the officer know that it is a refile?
An officer may know that it's a refile. I don't know that it helps or hurts. I never cared. One thing that when you're on the officer side, you can see multiple I-140s in an A file. And a lot of immigrants file and have filed multiple I-140s on their behalf for lots of different reasons, right? I call it, my analogy is as we diversify our financial strategies, we also diversify our immigration strategies. So it's not unusual to see an A file, if you get the whole A file, to see a labor cert in 2 or 3 different classifications, followed by something like an NIW or an EB-1. It's not unusual to see immigrants who are from visa regressed countries marrying somebody who is of a similar culture but is not from that visa regressed country, so that they can then cross charge with their spouse, and the spouse will have 2 or 3 I-140s in their A file, and then they'll have a 485, and then they'll, when the time comes, when that visa window actually opens again, they will have, maybe 2 different I-140s that are active, that are still pending job offers, and they can cross-charge to the country that with the least amount of regression. It's not unusual to see any of that on the officer side. These files get very big. I think when you're doing I-140s, you're doing the one that's right in front of you. And depending on whether you're working with individual clients or whether you have corporate clients, it could make a difference too, right? If you are working on the corporate side and you're doing a lot of labor cert, like E2, E3 labor certs, you're not around when that person finally gets tired of waiting and takes that bigger chance to do an EB-1 on their own or an NIW on their own. And sometimes, as for people who work with individual clients, sometimes they don't want that employer to know that they're trying to self-petition for another classification. People get cagey about different things depending on how the relationship is. And so it's not unusual at all to see that as a strategy. And what they're doing. They're trying to maximize these visa availability opportunities. And I didn't care. I knew what they were doing. I knew why they were doing it. For countries where there's a lot, or preference classes where there's a lot of regression, it makes a lot of sense. It's very expensive. The poor people, you look at these, alien files with like 3 or 4 I-140s, you're like, that's a lot of money and time. So yeah, I don't think it makes a difference.
Okay, thank you, Mandy. I have a question from Juliana. In addition to the professional plan, what do you think about expert opinion letters in the context of EB-2s?
I don't love them unless your expert really has a good connection to your client. I obviously, like with EB or with O1s, expert letters are required. But I tend to not use them unless there is a strong connection to the client. And then, okay, fine, right? So if you're doing, for example, a researcher kind of petition, and your professor or researcher is working for the #1 researcher in rice genetics or something, and that person offers to write them a letter of support, then yes, go for it.
Okay. Great advice, Mandy. Thank you. There's a question about why some cases take way too much longer than others in the similar situation.
Yeah, I don't know.
Okay.
It's supposed to be first in, first out. And the electronics adjudications is supposed to make that better, right? Because it's kind of easier to track. If these are cases that you paper filed, and I don't know how they did it. I don't know if they started intaking and at the lockbox and started like kind of from there in the last few months, or if they are trying to like scan and upload a bunch of old files. But I think if they're paper files, the paper file management system is just a lot. And the files, again, not that anyone here would ever lose track of anything physical. But they are in these big, it looks like a library. Okay. So they're on these big filing cabinets in big boxes based on filing date. And if something doesn't get pulled, then it doesn't get worked, right?
Yeah, it's a scary
Likewise, sometimes there can be changes in staff too, right? Like it can be assigned to somebody and then that person gets reassigned to another product, or they go on leave or something like that. And there's a delay in sorting out all of their assigned work. That can happen too, but I think that happens less than the other.
Question from Shelley. What are the qualifications of USCIS adjudicators at the service centers? Another speaker alluded to them not being college educated. Is this true?
Yeah, for some of them. There's multiple ways. There's multiple lines of progression for officers. I was hired under a hiring authorization that was looking for recent-ish graduates of at least a bachelor's, with at least a bachelor's degree. But there are many people who work, especially for Vermont and Nebraska, they work at the service center their whole lives. And there are many people who are retired veterans. Some of them went through college on their GI Bill, but many of them get hired because of their veterans preference points. You have to understand a little bit about the federal hiring process to understand how that can happen, how you can have all those people doing all the same job and getting paid the same. But it can happen. And I've been very impressed with people who didn't have the most impressive credentials. Oftentimes I'm more impressed by people who don't have the formal education because nobody has taught them this stuff, and they're quite good. And they're, like our union president, and he and I would kind of get into it a little bit, but he was a college grad or high school grad, started in the mailroom and worked his way up. And he was a very effective advocate on labor law, and he was a good adjudicator. I had another friend who started in the supply room. The service center used to have like an office supply store in it, and you could just go get whatever you needed. It was great. I do miss that. But I had a friend who worked in there. He worked in there for a lot of years, and he eventually he applied for an officer position. There's ISO 1s and ISO 2s, so there's two different levels. And he took the exam, and he passed the interview, and he got one of those adjudicator spots. So it can definitely happen. We had a security guard, someone who was a contractor for the security of the building, who went on to become an adjudicator. Mm-hmm. So in these smaller towns like Lincoln or Burlington, where you have kind of a limited population, people kind of figure out how to work their way up if they're interested in that, Mm-hmm. And I don't hate it. A lot of them are really good adjudicators. Mm-hmm. Some of them think they have something to prove, and sometimes they are just really good, and they just they didn't have the benefit of formal education. Mm-hmm. So I'm not a snob about that at all.
You don't think that impacts their ability to determine a criteria for the adjudication and learning and gaining from experience?
Nope. And I think, because the training is for non-legal people, right? And so the only thing I think that those people tend to struggle with a little bit more is the legal writing. And I think that most people here would agree. Sometimes that comes across. It doesn't really seem like they're being written by the most articulate legal mind out there. So for me, and they do have legal writing training that they do. They don't do that as often as they do forms training, which is unfortunate, but it's also part of the reason that they implemented the writing system that they have, right? Was to make it easier for people to have a base of professionalism and communication that maybe they wouldn't have in their regular vernacular. So and again, for me, what that eventually meant for me was I feel like now I adapt national interest waiver training at my firm to legal support and to our sales staff. I'm planning to do a session for our marketing staff too, because our marketers, they're trying to help this information be accessible to people who are interested in this service, right? And so being able to have that information be accessible, I think is incredibly important.
With any language, yeah.
Yes, I mean, and so I love the training that they do. And to me, when you can make something that's very complex,
simple,
very accessible to people without legal training, gold star. And they do that every day.
And that actually resonates a lot with us because since, most of our business plans, the ones we prepare, are focused on officers to review them. We try to keep it simple because there are some very complex businesses out there, and sometimes the relationships between the companies and whatnot. So part of what we do also within the business plans is try to keep it simple so that anybody could understand what it is you do, what is it that you're going to do, etc. So yeah, definitely we're fans of keeping it simple as well. Okay, let's go to another question. When officers are adjudicating employment-based I-485 case, do officers check responses to the RFEs issued for STEM OPT cases?
I don't think so. When you're doing a 485, the thing that you're going to be looking for is, at least on the I-140 side, is do we still have a job offer? In particular, when there is a gap in time, as there is now in the EB-2 category, between the I-140 approval and the adjudication of the 485. Right? So think about how much time it goes by between the I-140 getting approved and the 485 being adjudicated. It can be years. And it can be even longer if you're dealing with a beneficiary from a visa regressed country. So if you're a 485 officer adjudicating an EB-2 Indian national that has been sitting there for 10 years,
oh my God.
and there's 10 years between the I-140 adjudication and the 485, you're going to go out for an updated job offer. I think that's probably pretty reasonable. Mm-hmm. But in terms of like, the status review has to do with whether they had a lawful non-immigrant status for their time in the U.S. and whether they had employment authorization. And when you start to see gaps in the documentation, then you're going to start counting days. Mm-hmm. And so, you know, as a 485 officer, I would just keep notes on validity dates. And then if there were gaps, I would run it through a calendar, like a day counting software. Mm-hmm. Mm-hmm. Because if, you know, just to see if we were at or above 180 days. So, and I think the private bar does a great job of filtering those out. I mean, there aren't very many people who have big gaps that are applying to adjust. I mean, if there's a gap and they're filing for adjustment, they didn't think there was a gap.
Mm-hmm. Exactly. Okay. Another question from Yan Gao. After we win AAO appeal of an EB-1A I-140 case and the case has been remanded to the director, how long is it going to take for us to get the new decision, and where can we find an update?
I don't know. I don't know.
Okay.
I think those can take a while. Those are going to have to go through the full chain, right? They're going to have to be reviewed by center counsel. Mm-hmm. And center counsel is going to work with the supervisory team to kind of have a recommendation. The officer is going to have to then issue that decision. It can take a while. I would say probably a year-ish with everything else that's going on.
Okay. I have another question along the same lines. Many I-140 cases have exceeded the normal processing time by a long period, but USCIS responds to inquiries by saying the case is still within normal processing time. In this situation, how can we urge USCIS to take action?
I mean, I don't know that you can. I'm in the same spot as a practitioner. I have all the same tools available that everyone else here does. What I typically do is I try to get a sense of what they think normal is right now. And I wait until we've hit that normal, whatever their normal is. And then I file an SRMT. You know, with everything that's going on right now, I don't have high expectations of that process. It's very frustrating. I think it's frustrating for everyone at the service center too, because I think they want to get those files worked, but yeah, they had a big bubble.
Yes, they did. There's somebody asking if there are any informal country caps?
No.
For adjudicating. Okay, hard no. There's another question from Gabriela. What about sending government scholarly articles to evidence national importance, national initiatives, and urgency? Is there a number you recommend, or do you only recommend to send the most important ones?
Always the most important. You always have to prioritize. And the ones that are most closely connected to the work. That's something that I sometimes see in my practice. And this is just a function, I think, of people not really understanding how to connect the endeavor and the work, you know, the research that's out there from the federal government. If you really want there to be a connection between the government research and what your client is doing, it's not a spaghetti situation. You're not trying to throw this at the wall. and see what sticks. You're telling them, right? This is your case. You're prosecuting it. You need to be telling them this is the most important thing. And the government agrees this is very important. And my client is working on this very important thing. And so the most important part is the nexus between the research and the endeavor.
Okay. Okay, perfect. There's another question. We sometimes send commercial printout of portfolio of designers or artists with the hope of a good impression. Does that help?
I think it kind of depends on what it is, but yes, and I do that too. If I can have samples of work of any type of professional, I will include that. So for technology people, pitch decks, samples of the technology, visuals, helping the officer understand exactly what they're doing. Because for some professions, it's obvious, right? If you're a researcher and you've written 150 articles and you have 500 citations, the fact that your work is out there and recognized as quality work by others in your field is there. So for other people, what can you show when you need to show that they're good at what they do? And I think portfolios, again, you have to prioritize. You don't want to overwhelm the officer. You don't want to have it be confusing, but you do want to represent that person's unique and novel contributions and the reception of that unique or novel contribution by others in the field. And so sometimes you want to connect that with other evidence about the impact of that work or the recognition that that work has received or how important that work was to their business. So I would say make sure that you're connecting those samples either with your record of success arguments or novel contributions, and make sure that your letters of recommendation and things like that discuss those pieces of evidence and how they impacted the field or the business or whatever, right? So make those connections for the officers. Don't just say, here it is.
Exactly. Okay. I love that. Do you have any advice for dealing with RFEs where the officer clearly holds a bias against the beneficiary and seems determined to deny the petition regardless of the beneficiary's qualifications?
Refile it.
Exactly. That was my thought of what you were going to say.
Yeah. Yeah. We've talked about this enough.
Okay. We have a few other questions. Based on what criteria do I-485 officers choose to work on what cases every day? I don't know if you mentioned this already.
Okay, so for 45 officers most of that work is in the field now. So those aren't being done by service center officers. All of that comes up in a queue, a computer queue, and you just have to work the next file. There's an order to those computer queues. And so for 45 officers in the field, they will be reviewing them and seeing if they have to, they'll be reviewing whether they can waive the interview or whether they need to schedule an interview. And if they feel like they need to schedule the interview, then they'll be trying to figure out, what questions am I going to ask? Why do I need this interview? And if they're waiving the interview, are there any other pieces of the puzzle that I need to figure out? So is everything really in order? Are we still waiting on pieces? Do I need to verify employment? Things like that. The 693 rules have all changed since I was an officer, I think for the better. But sometimes there can be issues of, regarding the age of the 693. Again, visa regression, right? You have a window, you get your 485 filed, it regresses, your file can't be adjudicated for another 5 years. So
Exactly. We have 5 more minutes, so I'm going to take a few other questions. What percentage of EB-2 NIW cases that receive an RFE end up being approved? And how does receiving an RFE impact the overall perception of the case? Can it negatively affect the case even if the response is accurate and complete?
well, so I think I need to like unpack that question a little bit. So if the officer who's adjudicating the RFE response is likely the officer who issued the RFE.
Okay, but is it frowned upon that it received the RFE? Well, it doesn't matter. No, it was him,
They're
right?
frowning on their own work.
Okay. So he's saying, okay, I got an RFE. Let me take a look at it. Okay.
So for other officers, right? So let's say, you're a 485 officer, you're downstream, and you say, oh, well, this I-140 got an RFE. Are you going to go dig on that and see? Probably not. Ultimately, the I-140 was approved. If it's on your desk, it's because an I-140 was approved, or it's there for some sort of concurrent denial. For other I-140 officers, either who have taken over that file for reassignment or because there's a different kind of I-140 petition that gets filed at another time, sure, they can have their own bias. They may have bias for or against that other officer, right? If that's an officer that that you might be like, ooh, this person asked a question. Okay. And then you might have other officers that you're like, yeah, that person questions everything, whatever, so again, a little bit like our own practice, right?
Exactly.
We all have people in our offices that we trust their work a little bit more, a little bit less. Same thing.
Okay. Yeah, that makes sense. What if the RFE asks for documents we've already submitted with the initial application? Should we resubmit those documents along with an explanation in the RFE response, or would a clear explanation alone be sufficient?
So I think the way I typically try to address that is I will resubmit, and I will kind of point out this was in the original petition, submitting again here for clarity and in the interest. I think I usually say something like judicial efficiency. I try to like smooth it over. Like I'm being a little spicy, but I'm also smoothing it over. It's very easy to be reactionary to that kind of thing and to want to pop off, right? Like it's there. I mean, look at what I get. Look at what I put in the file. It's so easy to be spicy. Exactly. I don't recommend being spicy. The times where spiciness has really actually come out of my mouth, it's not been effective client representation. And so I don't recommend
take a breath. Yes. Wait one day, breathe, whatever you need to do. Count to 10.
Right.
Okay.
Sometimes too, just venting a little bit, just talking it through with other people in your office and then resetting and be like, you know what, if you need to see it again, I'm going to show it to you again.
Exactly. Yeah, that makes sense. Mandy, I think we need to do a volume 3 of this because it's time to wrap up and there are like 20 more questions that people asked. So I guess we'll probably be doing another session of this sometime in the future. But I wanted to ask you, Mandy, for some closing remarks. And of course, thank you for accepting our invitation and being here with us on behalf of Joorney. I wanted to tell you how grateful we are to have you as one of the speakers here at the summit.
Thank you. Thanks for having me again. It's just always such a joy. So great to work with you all. And I'm sorry the tech didn't work today.
No.
Thanks to Julia, who supported me through that difficult moment.
We're here for you, Mandy. Yeah. Yes, of course. Thank you, Mandy, so much, and thank you everybody for all the activity on the Q&A chat. It was amazing, and we hope that we can bring you even more valuable insights in the future from Mandy and from our other speakers as well. Thank you, Mandy. Thank you,
Thank
everybody.
you.